Sorry. Hello, everyone. Welcome to the 2023 Hot Topics in Environmental Law Summer Lecture Series. I'm Jenny Rushlow, Dean of Vermont School for the Environment. And we're very pleased to welcome you to the presentation today. Each of these talks is worth 1 Vermont CLE credit. So if you'd like to claim that credit, you'll need to keep track of the talks that you attend for your records. We'll have time for Q&A after today's presentation. And if you're watching on our school's YouTube or Facebook pages, you just enter your questions in the chat or the comment space. And you can do that during the talk anytime. We'll just collect them and I'll ask the questions at the end. Today, we're very pleased to welcome Chhaya Bhardwaj. Chhaya Bhardwaj is currently an associate professor of law at the Jindal Global Law School, assistant director of the Center for Environmental Law and Climate Change, and has taught at the Jindal School of Environment and Sustainability. Her teaching and research are at the intersection of law, environment, and climate change, and she writes on environmental laws, disaster laws, climate change, and international law. She's a member of the International Union for Conservation of Nature and rapporteur at the Sabin Center for Climate Change Law at Columbia University. She's also visiting faculty at Lloyd Law College, Greater Noida since 2019, and at the Indian Society of International Law since 2017. She's contributed to the work of international organizations like the United Nations International Law Commission, International Organization for Migration, and the Office of the United Nations High Commissioner for Human Rights on issues concerning sea level rise, climate change, protection of the atmosphere, human rights, and international law. She received an International Environmental Law Fellowship Award to pursue a master's degree here at Vermont Law and Graduate School. She also received a United Nations Fellowship to pursue a regional course in international law from the United Nations Office of Legal Affairs. And today, she'll present a talk titled Climate Change, the Biggest Human Rights Issue of the 21st Century. Please join me in welcoming Chhaya Bhardwaj.
Thank you so much, Jenny, for the introduction. I am really happy and excited to be delivering this talk here at Vermont Law School, the place that has actually motivated me to pursue this career as a professor in climate change and environmental laws. So I'm going to begin my presentation here. And so the question that I'm asking and presenting for this presentation is on climate change. Is it the biggest environmental rights issue of the 21st century? And so just beginning with some pictures from last 2 weeks from around the world, where flooding affected at least 3 continents across the world. There's the first pictures from Vermont itself, where flooding affected some of the regions in Vermont. The other picture there is from Spain, where flooding affected the regions in Spain. And the third and the last picture is from the northern parts of India, and flooding affected northern parts of India. And while it affected all of these regions, there were issues concerning human rights, and there were issues concerning the effects that it had on life and property both. Now, the learning objectives of this lecture are fourfold. I'm going to try to establish a nexus between climate change and human rights. I'm also going to discuss what are the conventional and other sources of human rights in the context of climate change. What are the key principles applied to protect human rights in the context of climate change? And what are the various tools and mechanisms available to protect human rights adversely affected by climate change? Now, climate change impact on human rights it is a twofold problem. The first problem is that climate change is man-made. It's anthropocentric, deriving from the anthropogenic emissions, essentially man-made, and has significant effects on full enjoyment of several human rights. The second problem is that there are certain climate actions that are well-intentioned, but in effect of their well-intentioned implementation, there are some repercussions and negative effects that cause effects on human rights. A classic example of this would be the recent studies that have been conducted on small island states, where countries like Fiji established climate action plans like building sea walls around their islands to protect people, but that well-intentioned program of building sea walls ended up affecting the human rights of the people of Fiji negatively. How? Because the wall was not well designed and it ended up causing more flooding than avoiding the flooding due to sea level rise. And so these are the twofold challenges that are associated with climate change impacts on human rights. And just broadly speaking, climate change today threatens a range of human rights. And to list a few, I have listed down these on the slide. Includes right to healthy environment for all, right to health, right to water, right to food, housing, self-determination, right to life, equality, culture, education, and right of future generations. Now, amongst these all, we see that in the international space, there is a phenomena where there are right to life related cases emerging in international law. And the two major decisions at the intersection of climate change and human rights that have happened in international law emerged from right to life under international law. The second more important tool that is being used today to understand the impacts of climate change on human rights, and also to develop tools to develop legal tools or judicial tools to reduce climate change impacts on human rights, is through the right of future generations. Now, this is still at a nascent stage and developing right now. And in the next 2 to 3 years, we will see a lot of legal, judicial, and policy frameworks around rights of future generations that'll be used as tools and instruments to protect human rights that are affected by climate change. Now, these are some of the pictures to contextualize the human rights that are affected because of climate change. Like I said, rights of future generation is one of the most important rights. Then we have right to life, right to food, right to adequate housing, right to adequate housing because we also experienced it in Vermont as well, that because of flooding or because of any disaster that happens, climate change related disaster that happens, the first impact that it has is directly on housing. And then, and due to which people are forced to leave their house and migrate to shelters or other places. And then in relation to this, the second and the third right that is affected is right to food, water, sanitation, and health. And in attachment to this, also right to family and culture. And these rights are sort of interlinked and interconnected with each other. The other right that is also important to understand is right to self-determination, which is also affected as a human right because of climate change. The contextual understanding of this would be that a lot of land is being submerged or being eroded, especially for the coastal states and small island developing states. Due to the erosion and loss of land, the people that are residing on those islands and that land are losing their right to claim those lands, and they're losing their right to self-determine their ways of living, their ways of functioning, and their ways of exercising their culture and other related rights. And so right to self-determination is also another important right that is directly being affected because of climate change. Now, these are the legal instruments that protect human rights. But before I talk about these legal instruments, there's one thing that I would like to highlight, which is climate change in itself is not directly impairing human rights. There is always one other causation or factor that is there between climate change and impairment of human rights. What does that mean? That means that climate change leads to extreme weather events that cause impairment of human rights, or climate change leads to shortage of natural resources that may cause violence and conflict that cause impairment of human rights. So climate change in itself is not impairing human rights, but there are adverse effects of climate change that are impairing human rights. And so fundamentally, human rights impairment or violation of human rights is also an adverse effect of climate change. Sometimes direct, sometimes indirect, but there's always this issue of causation that climate change is leading to extreme weather events like flooding that is then causing impairment of human rights, or climate change is leading to conflicts that is then leading to impairment of human rights. And so this linkage is really important to understand. This linkage also is important in the next slide, which is sources. Now, what are the legal instruments that protect human rights in the context of climate change? Now, whenever we talk about climate change, particularly from an international law perspective, the first source of law, or the first treaty or the conventional source that should come out is the United Nations Framework Convention on Climate Change, or the Paris Agreement. Now, unfortunately, both of these instruments do not detail out obligations to protect human rights. The Paris Agreement mentions protection of human rights related aspects in its preamble. However, it doesn't lay out, it doesn't specifically say that under Paris Agreement, the obligation of the states is to protect and preserve human rights in the context of climate change. And so there, the interlinkages become important, because if you're talking about climate change and human rights, the source of law under international law is not Paris Agreement or UNFCCC or the Convention on Climate Change. It is flowing out of the core human rights treaties. And there are 9 core human rights treaties, which I've listed out on the screen right now. The Convention on the Elimination of All Forms of Racial Discrimination, the Covenant on Civil and Political Rights, the Covenant on Economic, Social, and Cultural Rights, so on and so forth. Now, amongst all of these, there are these 3 core human rights treaties which are most active in relation to climate change related frameworks, advisories, or judicial decisions. And these 3 human rights treaties are International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights, and Rights of Child. Rights of child, because as I already highlighted, rights of future generation is very important right now in the context of climate change. And one cannot talk about rights of future generation without talking about rights of children. And so Rights of Children is currently working on developing jurisprudence and sources of law that can help build some foundations to how rights of future generation and rights of children can be protected. The other two sources of human rights treaties, the Covenant on Civil and Political Rights and the Covenant on Economic, Social, and Cultural Rights, are also important because the right to life cases are and the right to culture cases are flowing from both these. And there are two leading cases that I am going to be discussing today as we move forward. Now, I've already highlighted that Paris Agreement only mentions human rights in its preamble, but doesn't really lay out an obligation to protect human rights. Then there are other sources of human rights as well. All right. So most recently, I think one of the developments in international human rights law is that right to healthy environment was recognized as a human right. Now, if I compare it with with the US context, I think it is important to highlight that US still does not operate in the context of climate change on a human rights based approach. And so if I was to file a case saying my right to life is affected because of climate change, I think there is a gap there in the legal framework where it would not manifest or materialize. Whereas if I compare it with India, if I was to file a case saying because of certain actions of the government, my right to life was impacted due to climate change or non-action in relation to climate change, there are established procedures of law that will allow me to take up a right to life case before Indian judiciary. Similarly, there are right to life or right-based legislations in India in the context of environmental law and disaster law. Whereas I think in the US context, a right-based approach in the context of climate change or a rights-based approach in the context of environmental regulations do not exist. And so I think this is just in the US context, I think this is a gap. There's a gap there. But generally, as an international standard, right to healthy environment is now recognized as a human right. And states are under an obligation to take positive affirmative actions in order to protect right to healthy environment of their citizens or of all persons. All right. So what are the key principles that can be applied to protect human rights in the context of climate change? And these are largely 4 principles: equality and non-discrimination, transparency and inclusiveness, precautionary principle, and intergenerational equity. Now, equality and non-discrimination becomes important from a vulnerable group's perspective. Because if we look at vulnerable groups in context of climate change, especially in international law, indigenous people, women, children, migrants, persons with disabilities, and internally displaced persons are within the group of vulnerability. They are vulnerable groups. And so, and what does that mean? This means that these are the people who are going to be most effective in the context of climate change related disaster or climate change related conflict or climate change related adverse effects. People with disabilities are more affected when we talk about disasters. For example, flooding. People with disabilities might need special attention or special protection to be protected from disasters like floods. And so if we are talking about protecting human rights in the context of climate change, it is important to look at the principle of equality and non-discrimination, also from an equity perspective, because if you're talking about vulnerable groups, and for instance, people with disability, equality and non-discrimination may not look same for people with disability and people without disability. And so this principle should be kept in mind whenever talking about policy frameworks or legal frameworks in the context of climate change to protect human rights. The second principle that should be kept in mind is transparency and inclusiveness. And so whether it is urban planning or whether it is post-disaster response, or whether it is taking an action to reduce the effects of climate change, inclusivity of the people should be taken care of, and the processes should be transparent. And so transparency and inclusiveness should be part and parcel of applying human rights protections or protecting human rights in the context of climate change. The third important principle is precautionary principle. And precautionary principle intends to bring into effect the simple principle of precaution is better than cure. And at least in the context of climate change and human rights, what that means is that, say, for instance, in the context of disasters, if there are early warnings for floods, then early warnings can work as precautionary principle. There can be early evacuation of people. People can be brought to shelters, and people can be protected if there are precautionary steps taken to protect people from disasters. And so precautionary principle can be applied in the context of climate change. Precautionary principle can also be applied in the context of intergenerational equity. And so if we intend to protect the next generation from the adverse effects of climate change, then not just as a matter of precaution, but as a matter of hard implementation of climate action, it should happen right now. And then the last principle is, of course, intergenerational equity. Now, just to contextualize intergenerational equity from a disaster lens, in this age of man, in this age of Anthropocene, I think it is important to discuss that in cases of disasters, the next generation is almost in this vicious cycle of a lot of health effects, a lot of negative effects that might arise from these disasters. And so that is just one aspect of the adverse effects of climate change. Of course, just drawing an analogy, I might want to discuss the Chernobyl disaster, wherein after the disaster, there were a lot of intergenerational effects that were witnessed by the victims of the Chernobyl disaster, and they are witnessed even today. They are experienced even today. And so, in the context of intergenerational equity, it becomes important to look at the vicious cycle that disasters can leave whenever we are talking about climate change and human rights. Of course, Chernobyl disaster was one of the most extreme disasters that we can talk about as a matter of a man-made disaster. But even as climate change and its adverse effects are growing, the idea of intergenerational equity to protect human rights in the context of climate change becomes inevitable. Just quickly moving forward with what are the various mechanisms that are available to protect human rights that are adversely affected by climate change at the international level. Of course, I am not talking about protection mechanisms at national level, which vary from country to country, as I highlighted in the US, human rights mechanisms may look completely different from how human rights mechanisms may look like in India. But at international level, there are, of course, several mechanisms that can be used or utilized to protect climate change. The most popular ones that are emerging in the context of climate change is the climate litigation or the judicial tools or the quasi-judicial tools that are available at international, regional, and national level as well. For example, currently there are two decided cases, Ion Toshiota's case and Daniela Billy's case, which have become very popular cases which are discussing climate change and human rights. In addition to this, there are two advisory opinions pending before the international courts. One is before the International Court of Justice, and that advisory opinion will particularly look at rights of future generations. And it will be interesting to learn how that emerges and progresses. The second advisory opinion that is pending is before the Inter-American Court of Human Rights, and that is discussing a variety of human rights that are at threat due to climate change. And so all of these will become more important in next few months. Then there are Human Rights Council, which can be used as a tool or a mechanism to protect human rights. Human Rights Councils, they adopt resolutions. One of the resolutions recently led to recognition of right to healthy environment as a human right globally. And then there are other UN human rights mechanisms like the special procedure mechanisms, universal periodic mechanisms, and the human rights treaty body mechanisms where special rapporteurs can submit reports on variety of issues, one issue being climate change and human rights, other issue being rights of children and climate change. Now I will quickly go to the cases. And so these are the two cases which are important. And these are the only two cases we find in international law, which are sources of law and are at the intersection of human rights and climate change. So the first case of Daniela Billy is a case of climate refugees. Now, sorry, the first case of Toshiota is a case of climate refugees. Now, in Toshiota v. New Zealand, decided by the Human Rights Council in 2020, this was a very exciting case at that point of time because a lot of people thought that Toshiota and his family is going to emerge as the first climate refugees recognized by a quasi-judicial body globally, but that did not happen. So Toshiota, he had approached the Human Rights Committee saying his right to life is at threat because New Zealand government has decided to send Toshiota and his family back to Kiribati, the island where he was coming from. And he said that his right to life was a threat because his small island was already inundating because of sea level rise. There were no natural sources of water. The water was salinated, and there was no availability of drinking water. Also, his house where he was living before he moved to New Zealand was also inundated with water, was also flooded. And in addition to that, he had also lost a lot of agricultural land on which he could do farming and produce food for himself and his community in general. And so he said he and his family would like to be recognized as climate refugees under the existing law. And essentially, he argued that his right to life was at threat if he would be deported back to New Zealand. The Human Rights Committee interestingly said that yes, right to life can be applied to protect people as climate refugees. However, in case of Toshiyota, he failed to provide any evidence that can be used to protect Toshiyota and his family as a climate refugee. And so this was a very interesting case which recognized that climate change has negative effects on human rights, especially right to life, but at the same time and in parallel to this, they did not grant protection to Toshiyota due to lack of evidence. The rationale that was given by the Human Rights Committee was that Kiribati or small island nations, they are losing land, and so there is no right to life threat right now, but maybe next 10 to 15 years, when the sea level rises more, there may be a right to life threat then. And so the committee said maybe 10 to 15 years later, we can apply a right to life without any evidence in the context of Toshiyota's case. And that was the overall discussion that happened in Toshiyota v. New Zealand. And so one more interesting thing about this case is that this case is talking about forced migration of people because of a disaster here being sea level rise, a slow onset disaster, a disaster that is happening because of climate change. And so even here, the first adverse effect that is being recognized because of climate change is migration, forced migration or displacement. Now, the second case that has emerged from this jurisprudence of Toshiyota's case is the Daniel Belize case, and this was decided very recently in 2022. Now, here, a group of islanders, all Australian nationals, and their children, they submitted to the same quasi-judicial body, the Human Rights Committee. They submitted before the committee that Australia had failed to protect them in the context of climate change. Australia failed to take positive affirmative action to protect them, their culture, their family, and they let sea level rise happen, and they meaning Australia let sea level rise happen. Australia let the waters inundate their houses. Australia let their sacred places, religiously important places, to be inundated and flooded because of sea level rise. And because of this, they have lost a lot of things. And because of all of these losses, they have lost or their human rights have been impaired, and therefore Australia should compensate them. Now, amongst all of these things, three things are very interesting again. The first thing is that here they highlighted their right to culture, right to maintain their ancestral graveyards, and the indigenous nature of their rights. They said, we had an indigenous knowledge through which we would operate, but because of this anthropogenic climate change, we have not only lost our indigenous knowledge system, but we have also lost the sources through which we would exercise our indigenous knowledge system. And so essentially, they said that the inaction of Australia was causing impairment of their culture. Secondly, they also said because their homes were inundated and flooded, their right to have a family, their right to have privacy with their family was also impaired. And the third important thing that they said in this case was, or they claimed in this case was, that because they are losing their indigenous land, because they are losing their family and family homes, their children, who are going to be the next future generations of their indigenous knowledge and tribes are also affected, because they will lose the understanding of the indigenous knowledge or the culture or the indigenous lands that they would want to give to their children. And none of this is happening because they are doing something wrong, the islanders are doing something wrong. This is happening because the governments at large are failing to take action. And so all of this was taken into consideration. And the Human Rights Committee said that yes, Australia has violated right to culture, right to family, right to privacy of all of these islanders. But the committee prevented itself from taking any decision or laying down any standards on the question of rights of future generation. Now, the reasons as to why that was done was not laid out in the decision, but I'm guessing it is because there's a lot going on in the context of jurisprudence related to rights of future generation, and it'll become more important now as we move forward. Final and more important, or the most important aspect of this case was that this case was also founded on right to life aspect. So overall, the islanders said our right to life is impaired, but the court used its standard that it had applied previously in the Tishiota's case in 2020, when it said sea level rise is not causing damages to right to life today. Maybe next 10 to 15 years, it might cause a damage to right to life, but today, as of today in 2022, right to life is not impacted. And so that was the standard in relation to right to life that the court continued with. And so these are the nuances that were laid out after these two decisions in the context of international law. And so with that, I would end my presentation. And just to conclude, I would say there is a lack of legal frameworks or policy frameworks internationally and at domestic level as well when it comes to protection of human rights in the context of climate change. But they are developing right now, and I can only remain optimistic as to we will see more action through legal policy frameworks that are aimed at protection of human rights in the context of climate change. Thank you so much. I am open to questions. Thank you.
Great. Thank you so much, Chhaya, for that presentation. We do have a few minutes for questions from the audience. And if you'd like to ask a question, you can put it in the chat or the comment space on YouTube or Facebook, and we'll get through as many as we can. Chhaya, to start off, one of the issues that has been so challenging for climate change litigants in the US courts is establishing various elements of standing. And one of those is whether actual harm has occurred. And so many of the harms that come with climate change are, showing up in kind of preliminary ways, or sometimes it's challenging to prove that, the only cause of a disaster that's happened is climate change, or, we're kind of waiting for harm to occur before these cases can be successful in court. Can you talk a little bit about the nature of those kinds of standing issues when it comes to international human rights climate cases?
I think this is exactly what the Human Rights Committee did with the slow onset disaster issue in the case of sea level rise. So if you're saying that the actual harm is something that is to be proved before the US courts, was also exactly the case, was exactly the issue in relation to both the cases that I'm talking about. So even in both the cases, when they said that there was violation of right to life because Australia did not take action to protect the islanders, or that if Toshiyota is sent back to the small island, his right to life would be impaired. I think in both these situations, the decision of the committee was that there is no actual harm or imminent harm right now. Maybe next 10 to 15 years, there might be. And it is interesting because here, from a disaster perspective, what the court is doing, what the committee did was the committee established a distinction between a sudden onset disaster and a slow onset disaster. And so it might be easier to prove an immediate harm in a sudden disaster like flood or a cyclone or a typhoon, but it is, or a tsunami for that matter. But it is difficult to prove an immediate harm to life in the context of a sea level rise, which is slowly happening, or desertification, which is slowly happening, or melting of glaciers, which is slowly happening. So it's slowly happening. And, it might have happened now, but then according to the committee, it might take another 10 to 15 years. Now, the challenge with this sort of approach is that the committee is also directly or indirectly saying that until someone dies because of sea level rise, we wouldn't be able to establish linkage between sea level rise and threat to life. And this is a very dangerous road to take, just judicially speaking.
Something that strikes me about what you were just saying about the difference for standing with like a discrete event, like a typhoon or something, and long-term changes like sea level rise and desertification, is that I think those one-off events are particularly hard to from a causation standpoint to prove that that typhoon was caused by climate change and not, some random weather event that would have occurred even without the conditions of climate change. Whereas it's this like slow death march of climate change that does more clearly cause things like sea level rise. And so that's a real another catch-22 of the challenges of climate litigation that I hadn't, in the US, I haven't heard of cases where that focus on, well, it has to be a discrete event, we'll be more comfortable finding standing. I haven't heard that come up in the courts here. Maybe we'll start to see it more now that, the floods we just experienced, the heat we're experiencing farther west. It's probably starting to be more akin to what areas in South Asia and are already experiencing in terms of disastrous, specific events.
I think when you also mentioned international law and climate change and human rights, I think there's another example which recently has cropped up, especially in the US context, wherein New York was all full of haze and pollution because of something that was happening in Canada. And so now if we talk about just impairment of human rights because something happened on Canadian territory is also a matter of international law and impairment of human rights. But again, the idea to, establish responsibility in this context would be difficult because who really triggered climate change is going to be a very important question there. And it's obvious. And of course, it's different from, and something similar had also happened before in the Trail Smelter case, some 40, 50, 80 years ago, where there was a corporation because of which there was air pollution in the United States. But then there was an entity to which you could link the transboundary pollution and impairment of human rights in that context. But just in relation to these natural hazard-related disasters, it becomes very difficult to pinpoint responsibility for violations of human rights.
So building off that, a lot for lawyers who are working on these cases, particularly advocacy lawyers that are kind of looking for opportunities to shape the law around these issues. They're sort of shopping for facts, looking for the right case with the right set of facts that would be most likely to survive a standing challenge. And, given the various things that we've talked about here related to standing, which for, at least in the US, for climate cases has been that and sort of, venue, who has jurisdiction, state or federal, that kind of thing, has been a major hurdle. Can you think of a kind of, ideal set of facts that would have the easiest time finding success in this forum?
I think it's very, very difficult. And this is something I'm writing about also. There are so many advisory opinions pending right now. I think in that relation, if we're just establishing or trying to establish that one particular climate change event is because of a particular state, there's a lot of factual problems or challenges with that. But I think Daniela Billy's case was one case wherein, okay, if not right to life, they were able to establish violations of other human rights. And so right to culture, right to privacy, right to family. And so all of those were established just in relation to their own government's failure. And there they were eligible for compensation. And I think these sort of cases can be good factual cases. I could think of indigenous population being affected because of some inaction by the US government. If they were displaced, if they lost their family, if they're, I think there is currently in Louisiana, a lot of land has submerged below water. And I read some article where people were relocated from Louisiana to the mainland. And those people are currently being called as climate refugees within the US political legal system. And I think even those people could claim some sort of relief under the climate change law or in relation to climate change, if the US system allows it. I know a little bit about the US system, but not a lot. If that, I think that would be one of the cases, as far as I can think of, that would be easier to prove the standing challenge that the US government failed to take any action to protect their land or to protect their culture or to protect just their, right to live in the lands that they wanted to live in.
Okay, thank you. An audience question: why do courts, who are very intellectual and follow precedent, are they blind to following the science of climate change when considering present or future danger from disasters?
I think, again, this takes me back to what the Human Rights Committee is saying. If we're talking about disaster, there's always an element of uncertainty attached with it. And so, like sea level rise, the disaster, it may happen, it may not happen. What kind of repercussions or harm it will cause is always challenging. And so, yes, courts have been reluctant because I think they have not been able to devise a standard to implement precautionary principle related thresholds to protect people, or just to ensure that there is a duty to protect people. I think instead of just if we just started focusing on the duty to protect people, and wherein people can enjoy right to living in a healthy environment, I think that might help. But then there are also challenges to focusing on this angle as well.
Maybe with the time we have left, you could talk a little bit about the relationship in terms of responsibility between countries, coming out of the UNFCCC. There's a lot of discussion, that made a little progress at the last COP about the responsibility of wealthy nations to, offset damages for less wealthy nations. So maybe you could talk a little bit about that and whether you think we're headed in the right direction in terms of international responsibility.
Yes, I think again, at Conference of Parties, climate finance is one of the biggest issues, and transfer of technology is another. And I think there's gap or there's delay in both. And just from that perspective, I think there is lack of a political will to really engage in providing climate finance or transfer of technology there. So also unwillingness to really take climate responsibility. And while this is not happening at Conference of Parties, that makes me very skeptical of the advisory opinions that are pending right now. And so one is pending before the International Court of Justice, wherein they're going to talk about state responsibility for climate change. And I recently wrote an article wherein I discussed how this question in itself is so nuanced. There's historic responsibility, then there's current responsibility, and then there's all sorts of other responsibilities, per capita emissions responsibility, who's consuming more or responsibility, who's selling more and producing more responsibility. And so that categorizes states in a lot of different ways. And just from a historical responsibility point of view as well, we have ample science or evidence to say historically the developed countries or the West was responsible, but just that is not enough to pinpoint a single country for responsibility. It is not a straight jacket responsibility formula wherein we can be like, oh, okay, there's a dispute between Canada and the US, and something is happening on Canada's territory that is causing problems on the US territory. And so, we are pinpointing that and we are holding Canada responsible. So it is this whole question is very different from a very specific pinpoint responsibility. And so scientific evidences are going to be playing a very important role in this context. And so also a lot of questions are going to be raised, and there are dangers attached to it as well. And so if we have taken this question before the court, the decision of the court is going to inform a lot of next actions in relation to where the finance is going to come from or who's going to be responsible for climate technology transfer. And so there are also dangers attached with it, but then, all of this is going to unfold as we discuss it more.
Okay, thank you. Such a big topic, and thank you for laying the groundwork for this audience. We should wrap up there so that folks have time to get to class, but thank you so much, Chhaya, for that talk. And we will have another one of these talks here online on Thursday at 12. So we'll hope to see our audience there. Thank you. Have a good day.
Thank you.